Let's talk about packing the Supreme Court. Hey everybody, welcome back to Guns and Gadgets, your premier source for Second Amendment news. Fighting through the pain on this one. Let's talk about just that, packing the Supreme Court, and can they, being the Democrats, can they do it? Now, most of you know that the United States Supreme Court has 9 justices, but that has not always been the case. First off, the United States President, under the United States Constitution, Article 2, Section 2, has the power, actually it says they shall nominate justices to the bench when there's a vacancy. Another good thing to know is that while they serve life terms, that's not exactly what it says in the Constitution. The Constitution actually says that the justices shall hold their office during good behavior. Now that has, like I said, it's been interpreted to mean life sentences, but they also can be impeached. So the big question now leading up to this year's presidential election is, can they pack the court? Can a party add justices to the court, basically securing their ability to win every single case put forth under their term or during their balance of power? And the answer just might surprise you. See, the U.S. Constitution places the power to determine the number of justices in the hands of Congress. And that's done by passing an act through Congress, going to the president, where he or she shall sign it, or not. So what I want to do is tell you about some times throughout our history where the court numbers fluctuated. That, like I said, they haven't always been 9. So let's get into it. The very first Judiciary Act was passed in 1789, signed into law by George Washington. And that set the number of Supreme Court justices to 6, with 1 Chief Justice and 5 Associate Justices. And we'll go over the differences and the different numbers over the years, but it's good to note now that the number of authorized justices has been as low as 5 under John Adams and as high as 10 under Abraham Lincoln. So like I said, George Washington signed the first Judiciary Act into law with 6 justices. And what they never really thought of at the time was the potential of a 3-3 tie. Why? Well, see, back then, all the judges were Federalists, and they never ever foresaw something like we have today. They never saw a disagreement on the constitutionality of a law. Plus, during that time, they didn't always have 6 justices sitting on the bench during a specific given case for a couple reasons. First, for health, and the second was travel. See, back then, the Supreme Court justices were also appointed to sit on the federal courts, and back then there were 13, 1 for each state. At that time, almost the entire year for a justice was spent traveling. So the number stayed 6 up until 1800, when John Adams lost the presidential election to Thomas Jefferson of the Democratic Republican Party. See, Adams was a Federalist, and the way he tried to keep his party in power was to reduce the amount of Supreme Court justices to 5. And he did that by signing into law the Judiciary Act of 1801. See, back then, the lame duck period lasted until March, so Adams had some time to get this done. However, that didn't last long, as Jefferson and his newly elected Congress repealed the Judiciary Act of 1801, bringing the number of justices back to 6, so the authorized complement, if you will. It also should be noted that the number never dipped to 5 as far as the number of justices, because there were no deaths during that period. During the Civil War, the number of justices increased to 9 in order to help accommodate the growing and expanding American West, the Western frontier. And then came the Dred Scott decision. If you're not familiar with Dred Scott, that was a Supreme Court case in which a former slave, Dred Scott, lost his fight for freedom, and this just infuriated President Lincoln, and at that time, he wanted to cement in an anti-slavery majority into the court, and he ended up signing into law an authorization for a 10th Supreme Court justice. And that happened in 1863. Then came Andrew Johnson, and Congress wanted to limit Andrew Johnson's power, which they were able to do because they had the majority at that time. And in 1866, legislation was passed to cut the authorized complement of the Supreme Court to 7 justices. Then Ulysses S. Grant in 1869 signed the Judiciary Act of 1869, which authorized the number of Supreme Court justices to 9, and that has been where we have sat since. Now, there has also been another attempt to add to that since, and we have to talk about that as well. In the 1930s, Franklin Delano Roosevelt had this thing called the New Deal, and the Supreme Court at the time, through a series of decisions, undermined a majority of his very liberal New Deal. That angered him, so he had his legislators respond with a bill that would seek to authorize FDR to nominate an additional 6 justices to the Supreme Court, bringing the number to 15. He also had another caveat in there that if a judge was over 70 years of age, then they would be asked to resign, and if that justice refused to resign, that would allow FDR to nominate an additional justice to the bench. Luckily, that was shot down in the Senate by a vote of 70 to 20. So that is a quick history of the staffing numbers of the Supreme Court. And I hope that answers your question. Yes, they can stack the numbers in the Supreme Court. They can pack the court to favor them. Doesn't matter if it's just the Democrats. Republicans could do it as well. Anybody can. The only thing it requires, according to the Constitution, is an act through Congress. Now, ideally, that number should not be huge and should always be an odd number. But what do you think? Should there be more justices on the Supreme Court? Is there enough now as it sits? I'd love to hear you sound off, because I know not everybody who watches my videos is a staunch Republican or somebody who is a, believe it or not, staunch constitutionalist. And I do value people's opinions. Not everybody has to believe what I believe. So I would like to hear some of them down below. I think 9 is a perfect number for several reasons. First, it takes long enough for 9 people to hear these cases. If we had 15, 20, 30, how long would it take to get one case through? It would be ridiculous. And of course, an odd number is perfect because you avoid that split, or that tie, if you will. So I figured now would be a good time to do a quick little history of the United States Supreme Court, because Joe Biden and Kamala Harris and Nancy Pelosi and Chuck Schumer and Jerry Nadler have all said that if Donald Trump nominates Amy Coney Barrett to the Supreme Court, which he has, that they would respond by stacking the court. Again, they assume that they're winning this election, but they have come on record saying that they will stack. Even people like Joe Kennedy III in Massachusetts, people who don't really have any stroke, but the thought is out there again. We haven't seen this since FDR in the 30s, but it's definitely back. Let me know what you think about it down below. Thank you for your time. I appreciate it so much. Please subscribe to the channel if you haven't already. This is where you'll find news on the Second Amendment, as well as some historical facts as we go along. I also have that playlist, Remember in November, just to point out some facts about the people seeking office that want to slash away at the Constitution. And if you could, hit the thumbs up so that more people can see this and share it with some of your friends. And until we see each other again, be safe, stay vigilant, carry a weapon, and I'll see you on the next one. Take care, everybody.